In the matter of A2517, Ray Accutane Litigation, may we please have appearances of counsel?
Good morning, Your Honor. Now
Good morning, Your Honor. Good morning, Your Honor. Edward Banning from McCarter English on behalf of 4 amici, the Healthcare Institute of New Jersey, the New Jersey Business and Industry Association, the Commerce and Industry Association of New Jersey, and the New Jersey State Chamber of Commerce.
Good morning, Your Honors. Bruce Greenberg, Light Palmer Greenberg, New York. On behalf of the plaintiffs, the respondents in this court, I'll be splitting this argument with Mr. Buchanan, who will give his appearance next. I'll be addressing the appropriate legal standard, and Mr. Buchanan will be addressing the methodology and the science in this particular field.
Good morning, Your Honors. David Buchanan, Cedar Weiss, for the plaintiff respondents.
Good morning, Your Honor. Christopher Pascal, Colin Pascal Roth, on behalf of Amicus Curiae, New Jersey Association for Justice. Thank you.
Morning, counsel, and welcome. Mr. Schmidt, I have you arguing for plaintiff. Appellants, excuse me.
Thank you, Your Honor. May I proceed?
Please.
Paul Schmidt, Your Honor, may it please the court, for the Roche appellants, I request the ability to reserve a few minutes of time for rebuttal.
That's fine.
Expert admissibility involves a balancing between the undisputed right of the plaintiffs to put forward expert testimony if it's scientifically reliable and scientifically founded, and the undisputed right of the defendants to be protected from the prejudice of expert testimony that is not scientifically founded and not scientifically reliable. This court has recognized that prejudice in individual trials. It's particularly true in a scenario like this, where we're looking at the possibility of over 2,000 trials. That balancing matters. It matters to the parties, it matters to the integrity of the courts and the fairness of the court system, and as the amici illustrate in this case, it matters outside of court in terms of the impact of litigation outside of court. And I would highlight the brief from the American Medical Association and the Medical Society of New Jersey, pointing out not only how far outside the scientific mainstream Dr. Kornbluth's methodology is, but the real-world consequences of that in terms of public health. Over 25 years ago, this court led the nation in striking that balancing through gatekeeping by saying that an expert could testify if they employed in court the reasoning that scientists use outside of court and the methodology that scientists use outside of court. Under this court's precedent, it's not enough for an expert simply to invoke magic words and say, I use something akin to Bradford Hill. The reasoning and the methodology matters. In the words of Landrigan, the expert must show the validity of the expert's reasoning and the methodology. And that's the focus that the trial court in this case applied to Dr. Kornbluth. And I'll focus my argument on Dr. Kornbluth because he really stands alone in this appeal in terms of his place in the scientific world, being the only scientist in the wake of the studies who uses the methodology he does to reach a causation opinion as to Crohn's disease. And even in the context of this litigation, where the other 2 plaintiff causation experts who have appeared in this litigation, Dr. Sacker and Dr. Madigan, have not given the broad Crohn's disease causation opinion that Dr. Kornbluth gave. And I'll focus on 2 core methodological defects with Dr. Kornbluth that the trial court highlighted. The first is his privileging of weaker evidence over stronger evidence. He privileged exploratory hypothesis-generating evidence, individual case reports, small dog studies, theories about a mechanism of action, over the very type of evidence that the scientific world recognizes tests that hypothesis. 9 large-scale studies that again and again tested his hypothesis and found it lacking. The trial court properly recognized that by privileging the weaker evidence over the stronger evidence, he departed from a basic scientific norm. In violating that norm, his methodology was defective in a second critical way, and that was the rationale he gave for not following the studies that he then abandoned for the weaker forms of evidence. For the studies, he repeatedly advanced arguments for why they were insufficient. In his view, some of them were too small. In his view, some of them didn't look at patients for long enough, given how long it takes Crohn's disease to develop, the prodrome. In his view, some of them looked only at IBD or didn't look at the right dose or didn't take account of the right confounders. Again and again, he made those arguments against the studies, and again, he abandoned those arguments so that he could embrace the weaker forms of evidence when, had he applied his arguments even-handedly, he would have had no evidence left to rely upon. And it's self-evident that an internally inconsistent methodology is not a scientific methodology, as the trial court properly found. No expert has used Dr. Kornbluth's methodology outside of court in the way that he uses it. Dr. Kornbluth does not use outside court the methodology that he uses inside court. In fact, he's contradicted his in-court methodology in his only outside publication on Accutane, looking at ulcerative colitis. We would submit that it's simply not possible to review the studies and the science and the literature in this area and not see how far outside of a reliable scientific methodology Dr. Kornbluth is. It's not possible to consider his arguments for disregarding stronger evidence that he then abandons to embrace weaker evidence and not conclude, as the trial court did, that he's not employing a reliable methodology.
It sounds like your application of the test requires a testing of the methodology based upon the facts specific to this case. Is that correct?
It requires looking at how the expert applies their methodology to the facts of their case, how they reason based on the facts of this case.
Do you see that as an addition to our current test?
No, I think that's heartland in line with this court's prior precedent, which is why we view the appellate division decision as a deviation from this court's precedent. Looking at cases like Landrigan, an expert must demonstrate that both the factual bases and the methodology are scientifically reliable. Landrigan, the trial court should review the studies as well as the other information proffered by the parties to determine if they're of a kind on which experts would rely. Rubinek, again, the expert must show that they are using a methodology involving data and information of the type reasonably relied on by experts in the field.
So I know you're focused on the facts of this case, but it sounds like you're adding words to the Rubinek test that align it with Daubert.
No, I don't. That's not our intention. We don't view this court's precedent that way. This court's precedent, we think, sets some very basic principles that Dr. Kornbluth ran afoul of. One, that an expert must do in court what scientists in their fields do outside of court. We know broadly as to how he treats that evidence, that's not the case. We know as to his methodology, that's not the case. And two, the court examines the reasoning. Every step of the reasoning, I believe the court said in Landrigan, every step of the reasoning must be examined. And here, where his reasoning literally contradicts itself, that runs afoul of this court's precedent. The Daubert addition would be, I think, the Daubert factors, which he also runs afoul of in terms of no peer review, no testing, no known error rate, no consensus. Some of those are recognized under New Jersey law, but they haven't been adopted.
Just to be clear about what the test is it your position that Rubinek and its progeny are not materially different from Daubert?
No, our position, I think Rubinek and Kemp and Landrigan go to the same goal that Daubert tries to achieve, which is looking at whether the expert does in court what they do outside of court, ensuring that they use a proper methodology, looking at the reasoning, looking at how the methodology is applied. Daubert has the additional specific Daubert factors, and that's where I think there is a difference.
So why don't you tell us what you think the difference is?
My
question is, are they materially different, or are they different at the fringes?
I think probably somewhere in between, Justice Albin. They have the same goal, they have the same focus, they have the same standards in terms of reasoning and methodology. They're different in that New Jersey has not formally adopted the Daubert gatekeeping standards, although it's recognized the relevance of consensus, for example, it's recognized the relevance of peer review. It hasn't formally adopted those factors, and that's the difference.
Drill down a little bit further and specifically tell us the differences as you see them and why you would favor one over the other for the appropriate legal standard.
Sure. I think the differences are twofold. One is the Daubert factors that have been adopted in the federal court system and have not been formally adopted in the New Jersey court system. The 4 Daubert factors: known error rate, testing, peer review, acceptance in the field, consensus in the field. And then I think the second difference is it's unclear under New Jersey law, although notably both the appellate division and the trial court in this case cited Daubert case law, it's unclear under New Jersey law how much Daubert case law is applicable in a case like this, how analogous it is. And courts have differed over that question. So I think those are the two differences. The benefit of following those standards, the Daubert criteria and Daubert case law, would simply be certainty in terms of the application of New Jersey's already existing standards by trial courts, by appellate courts.
But it's your position the outcome does not depend upon whether or not the Daubert standard applies or the Vanek standard applies. That's your position that the trial court properly exercises gatekeeping role in denying the testimony here.
That's absolutely correct, Justice Alvin, that under this court's precedent that requires an examination of reasoning, requires an examination of methodology, each step of the methodology, under this court's existing precedent, the trial court reached the right outcome here, and the appellate division, in our view, erred by essentially reading those requirements from this court's precedent out of New Jersey law in terms of saying, we're not going to evaluate the reasoning as this court has directed and as the trial court did. If there's a plausible argument, we're not going to go through the methodology and see, is it more than just invoking the magic words Bradford Hill? Is it actually applying it in the way that scientists in the real world do? That's what the trial court did, as directed, I think, by this court's precedent, even the procedural aspects of this court's precedent. It wouldn't make sense to have a Kemp hearing, to have it be reversible error not to have a Kemp hearing, if what the trial court were doing were simply saying, does this expert say they use Bradford Hill? Do they say they review all the evidence? Are they credentialed? Even this court's procedure, I think, contemplates what the trial court did.
So you think the adoption of those factors would further channel a court's review of experts such as we have here? And also, do you think it would affect the standard of review? Do you think the appellate division applied it more closer to a de novo review in this instance?
I think to answer both those questions, Justice Lavecchia, it would add certainty, I think, to New Jersey law. It would give guideposts, both in terms of the factors and in terms of just by nature of the size of the country versus the size of the state, a much larger body of cases applying Daubert. That would give certainty, and that would be a benefit to trial courts in terms of trying to apply the very gatekeeping standards that New Jersey already recognizes, led the country in recognizing.
Yeah, Counselor, in this particular case, the appellate division initially indicated that the abuse of discretion was the standard for trial court's ruling, but then it indicated that because it was expert testimony, they wrote somewhat less deference. What is your position on that?
I think we would take the view that abuse of discretion should mean abuse of discretion, and if there is abuse of discretion review, it should apply on a record like this in terms of the unique aspects of this record, where the trial court did exactly what trial courts have been directed to. Before the Kemp hearing in this case, the trial court asked that all the studies be submitted to the trial court. The opinion the trial court wrote makes clear that the trial court reviewed, as this court has directed, only the studies the parties were relying on and nothing else. The opportunity to actually be a part of a lengthy, I believe it was 10-day Kemp hearing, and actually ask the witnesses questions about their methodology to try to understand their methodology. All of that, I think, is the basis for abuse of discretion review. All of that applies particularly clearly here, given the nature of this proceeding.
Could you tell us where you think the experts went wrong, plaintiff's experts went wrong in their use of the Severin report?
Yeah, that Justice Lavecchia is a perfect example of our core concerns with not their conclusions, although we do have those concerns, of course, but with their methodology.
Right.
There was one study that had a big number in it, Sivaraman. It happened to be the smallest study. It happened to be the study most subject to the criticisms that Dr. Kornbluth was making of the other studies. But because that study had a number in it that he liked, he relied on it. He relied on it heavily. He relied on it in a way that even the authors of the study said was improper, because they attempted to adjust their study for some of the very confounders that Dr. Kornbluth said you need to adjust for, and he said, I'm going to ignore that adjustment. So it's an example of the fundamental incoherence in his methodology, where larger studies are too small, but this small study is big enough, literally 3 Crohn's disease patients. Larger studies didn't look at patients for long enough because of this prodrome issue. He can't say Sivaraman wasn't subject to the exact same prodrome issue. Larger studies may not have looked at dose well enough. He can't say anything about the dose in Sivaraman. Larger studies have other design flaws that he raised and that the trial court documented in his decision. He can't rule out those design flaws in the Sivaraman study, but that one he can make an argument on, so he embraces it and discards his own methodology as applied to the other studies.
Well, how about the prodrome issue? Because that seems to be really central to Dr. Kornbluth's argument,
Yes,
attempting to deconstruct all of the other studies. He's claiming that the look-back period is 2 to 4 years, and that many of these studies were based upon a 1-year look-back, and therefore they should be discredited because they therefore were not including a number of Crohn's cases. Now, tell us why that is not a reasonable scientific approach.
Well, 2 reasons, Your Honor. One, it's not a scientific approach we see outside the courtroom. The authors don't identify that as a concern. He doesn't identify that as a concern outside the courtroom. But 2, and I think this is the really critical point, is if that's his standard, it should be evenly applied. The essence of a scientific methodology is that it's even-handed, that it doesn't apply different rules based on whether you like the evidence or whether you don't. And he didn't apply that prodrome rule even-handedly. My colleague Colleen Hennessy was able to very ably demonstrate that within a page of his testimony, of him demonstrating that he was not looking at larger studies because of this prodrome issue, where the authors of those studies themselves said, by design we focused on a shorter study period because we wanted to evaluate temporality. He rejects that. A page later, literally in his testimony, he says, a case report, a single report where a patient reports Crohn's disease shortly after using Accutane, that's compelling to him on that very issue, temporality.
Is there a reasonable dispute within the scientific medical community about the look-back period, about the incubation period for Crohn's, and whether or not it's greater than 1 year?
We don't think,
is that subject to reasonable debate?
we don't think there is, and his argument on that point depended on endorsing a few outlier studies and disregarding the majority of the studies involving tens of thousands of patients that showed less than a 1-year period. But there is absolutely no debate in the scientific community that you can't have one rule for the evidence you don't like, the better evidence, and another rule for the evidence you do like, the weaker evidence, when it should apply equally if that's a concern.
That I get. You're pointing out inconsistencies. But it's your position that there is no debate in the scientific community in terms of the prodrome period?
I would...
That some experts in the field say that the look-back period should be 2 to 4 years because symptoms to diagnosis may be more than 1 year, and if you're only doing 1 year, you're not necessarily capturing the proper number of cohort cases. You following me?
Yes, I do, Justice Altman, and I think there probably is debate in the scientific literature over precisely what the prodrome is. There is no debate in the scientific literature outside of Dr. Kornbluth in a courtroom over whether all of the studies can be disregarded on that basis. We put in the record the slides that we used for the closing, including one at DA 241, that groups the studies and the massive number of studies that show a prodrome of less than a year, and the outlier studies, particularly the Pimentel study he relied on, that are out at the extreme. Now, that probably does reflect something of a debate. The key question from our perspective is no one in the scientific community says, based on questions about precisely how long the prodrome is, we can disregard this body of study data, which is effectively what he does.
But wouldn't it thoroughly, if the look-back period were truly 2 to 4 years, and major studies were based upon 1 year, wouldn't that seriously undermine the validity of those studies?
If that were true, it would as to those studies. It wouldn't as to the other studies that he acknowledged don't have that problem, including one that found a statistically significant reduced risk of Crohn's disease with Accutane. It might as to the others. Our point is simply, it's unreliable for him to go through the prodrome data and say, I like this outlier study, I'll ignore the much larger studies, even as I say power is a critical issue. If power is a critical issue, how does he base his prodrome opinion on a 26-person study and disregard 10,000-person studies? There's certainly no reliable basis to apply that to the studies, but then say case reports are compelling after I've disregarded the studies on this basis, when the case reports are subject to the very same critique. And that's the heart of our challenge to Dr. Kornbluth, is one set of standards for the evidence that helps him and another set of standards for the evidence that cuts against him.
Even if the epidemiology studies can be discounted for reasons that the plaintiff's experts point out, would it be a reliable methodology to then turn to the case studies which you mentioned, as well as animal studies to support the position, or would it the better result to be to say that the evidence is simply inconclusive at this point?
I think on this record, that would be the scientifically accurate outcome, to say the evidence is inconclusive. Certainly, we're not taking the position that a court can never look at animal data, or an expert can never look at animal data, or can never look at case report data. Certainly, that can be part of the calculus that an expert performs. Our argument is, in this setting, with this set of data, where he's disregarding the hypothesis testing data that refutes the hypothesis and only looking to the hypothesis generating data, that's improper. When he applies one standard to get rid of the hypothesis testing data and another to embrace the hypothesis generating data, that's improper.
So I understand that, but before these more recent epidemiological studies, you were looking at case reports, adverse event reports, animal studies, and these cases were actually going to juries. So if these epidemiological studies were not around, would it be your position that the science was too uncertain to permit these cases to go to the juries, as they already have?
Yes,
Go ahead.
and that was our position. We prevailed in the federal MDL on that position. We did not prevail in the appellate division on that position before the studies. But the critical view, I think, in this context is the appellate division decision that admitted that testimony made a point of admitting that testimony in the absence of study data, testing that data, saying that if there were study data, that would be the better data. That's a uniform, universally recognized principle of science. Now that that study data exists and now that it shows what it shows, it makes especially critical. How does he process that? How does he respond to the science, argue away the science, but still embrace the case reports and the 50-dog study and his theories about mechanism? And that's where the methodological issue arises.
I think your adversary is going to say that we have enough. We've crossed the threshold to get to the jury, and that if your arguments are so persuasive, if all of your epidemiological studies are on point, then you should be able to crush them before a jury. So how do you respond to them?
I think that's just an argument against methodological gatekeeping. Methodological gatekeeping recognizes if this were a question of are we right or are they right, we'd win. If it were general acceptance, we would win. No one outside of court holds the views that they seek to offer inside of court. This court has said that's not the standard. The standard is methodological gatekeeping, and it's methodological gatekeeping because of the recognition that juries aren't always well positioned in the context of a trial to assess expert methodology, that there's prejudice from sending methodologically unreliable evidence to a jury. And that's the heart of our challenge here. The methodology that he uses is unreliable. To say you can just fight that out in front of a jury, or in this case in front of 2,000 juries, that's the very reason gatekeeping exists, because of the recognition that credentialed experts can have an undue influence on a jury, even when they don't use methodologically sound methods. Otherwise, we would simply be talking about credentials. We wouldn't be looking at methodology. That's the essence of methodological.
Are you saying his methods are no longer reliable in light of the epidemiological studies? Because before they existed, the type of analysis that Kornbluth was doing was what experts did in these cases. Am I mistaken?
I think in the sense that Dr. Kornbluth was in these cases, so we never saw his method in the absence of the epidemiology. But the broader answer, I think, to your question, Justice Alban, is that an expert has to address all the data. No one disputes that. It's the manner that he addresses all the data that he acknowledges is, in the abstract, the better data, the hypothesis testing data. There's not a dispute in this case over what's been referred to as the hierarchy of evidence, over the proposition that some evidence generates hypotheses, other evidence, like these studies, tests hypotheses. The scientific literature widely recognizes that. Dr. Kornbluth acknowledged that as a general norm of science. The dispute is, how does he handle that evidence? That's a core gatekeeping issue. It's not so much a matter of how he responds to new evidence. He never addressed the prior evidence. It's how he responds to the full set of evidence before him. And again, we know the way he responds is to invert scientific principles, to use one standard to disregard evidence that cuts against him and use another standard to embrace evidence that is weaker, that he acknowledges is weaker, that he acknowledges has limitations, when if he applied his standards even-handedly, he would have no evidence left to rely on. He would be inconclusive.
Are you saying it's not a question of which evidence is stronger, which one's, but the fact that he ignored any evidence that he didn't like, is that the core issue here?
Yes, I think Dr. Kornbluth would say he didn't ignore the evidence.
But he disregarded it.
But functionally, he disregarded it. He has a wonderful quote where he says the overall studies did not inform the issue for him. Large-scale human studies have such a compromised analysis that, quote, they lack the ability to reasonably inform the issue. And then in the case of the IBD-specific studies, he said he didn't rely on them at all. I didn't look at IBD. That does not inform the assessment of Crohn's risk. He then abandoned that methodology, that standard, to embrace any form of non-study data. IBD case reports, dog studies that didn't even involve IBD, vesinoid data where he doesn't know how large the data set is so he can evaluate whether it's powered. He doesn't know how long it was studied. He knows it's not any form of inflammatory bowel disease. Again and again, it's having one set of standards to disregard the better evidence, even if we were to ignore it being better evidence, some body of evidence that the scientific community looks to as speaking to this question, peer-reviewed, published evidence, and then embracing another body of evidence where he can only do that by disregarding his own standards. That was not incidental to his methodology. That was the core of his methodology, to have one standard for the evidence that cut against him, what the scientific community recognizes as the better evidence, and another standard for the evidence that he wanted to embrace. That's heartland unreliability, and our view is that if methodology means anything, it means that an expert who inconsistently applies his standards can't testify, can't show that they have a reliable methodology.
Can I ask you a question about one of the sort of remarks or findings by the trial court? He seemed to put an emphasis on the fact that attorneys were reporting adverse events and it was distorting the statistical body of evidence. What is there any truth to that from your perspective? Is there anything wrong with attorneys making these reports? Go ahead.
No, there's not. What I think the relevance of that issue is attorneys, I think in most of these instances, don't directly report cases to the FDA. What happens is when they file a lawsuit, the company treats the lawsuit as a case report and reports it to the FDA. And so that increases the number of case reports. The relevance of that is this argument that we sometimes hear that case reports are undercounted becomes less forceful when we know that there's been what's referred to in the scientific literature as stimulated reporting, when there's been advertising and lawsuits, and as a result, a larger number of cases filed. From our perspective, that's the only relevance of that issue. Otherwise, I don't think I would have much to say about that issue. It doesn't change the core fact that case reports by themselves, whether they're originating as a result of a lawsuit following attorney advertising or following something else, or whether they're coming from a doctor, they have inherent limitations. Those limitations are recognized by the scientific community. They're subject, and this is critical, to every one of the limitations that Dr. Kornbluth identified with the studies. Prodrome, certainly power, some of them aren't Crohn's disease, dose, confounders. Every one of those limitations would doom the case reports. That's why they appear lower on the hierarchy of evidence than hypothesis testing studies. Our problem with his use of the case reports focuses more on simply, if he applied his standards even-handedly, he couldn't embrace the case reports in the way that he did.
Other questions, anyone?
Thank you, Chief Justice. I'll reserve whatever time I have left for rebuttal.
Mr. Cannon.
Morning. May it please the Court, my name is Edward Fanning, and I represent 4 different amicus curiae in this matter. They are the Healthcare Institute of New Jersey, the New Jersey Business and Industry Association, the Commerce and Industry Association of New Jersey, and the New Jersey State Chamber of Commerce. Together, these amici represent a significant cross-section of New Jersey's vitally important life sciences industry, our state's employers from our largest to our smallest, and our business leaders. We are here today because, in the view of our clients, this case presents an opportunity for this court to join the mainstream, to join 39 other states, the District of Columbia, and of course the federal judiciary in using Daubert as the standard by which to evaluate expert admissibility. We submit there are three compelling reasons why this court should do that. The first is that the adoption of Daubert, in our view, would ensure that juries in New Jersey are presented only with real science and with reliable expert testimony. Second, the adoption of Daubert would help ensure that results of litigation here in New Jersey are consistent with litigation in other jurisdictions around the country. In this age of serial litigation, often involving the same defendants, involving the same product, but involving thousands of cases filed in different jurisdictions around the country, the adoption of Daubert here in New Jersey would help ensure that consistency with results reached in other jurisdictions that do employ Daubert. And third, we believe that the adoption of Daubert would help reduce the likelihood that this state will become, or in the view of some, remain a magnet for litigation based upon unproven and unreliable expert testimony.
Tell us, please, what you perceive as the principal differences, both in theory and in practice.
I would agree with what Mr. Schmidt offered to the court this morning, Your Honor. I think that although Daubert and our state's jurisprudence, and I include in that Landrigan, Rubanek, and Kemp, have the same goal, there are real and consequential differences in how they are applied. So even though there are aspects of the gatekeeping role that we hear well defined in Daubert and its progeny, in our jurisprudence, we do not have that same level of definition with respect to our jurisprudence here in New Jersey. And as a result, we think that as a practical matter, and as we've demonstrated, I believe, in this record, that we have situations where courts here in New Jersey are admitting into evidence and allowing juries to hear testimony from experts who have been deemed unreliable when they are tested under the Daubert standard. One example that we give is in the Zoloff litigation. In that litigation, there was parallel litigation going on in the Eastern District of Pennsylvania, where, of course, the Daubert standard was applied, and there was litigation going on here in New Jersey. The plaintiff's causation expert in the Zoloff litigation was barred because they did not meet the Daubert standard. However, when those same experts came across the river here into New Jersey and were tested under a Kemp standard, those experts were permitted to testify, and tellingly, to Justice Lavecchia's question, the trial judge here in New Jersey observed that unlike the Daubert factor-based approach, in New Jersey, the trial court need not consider factors as to whether the expert's hypothesis can be tested, whether the methodology is subject to peer review and publication, and whether the methodology has actually been accepted. Those are just some of the Daubert factors. So
those Daubert factors are not conjunctive, they're disjunctive, aren't they? A scientific opinion doesn't necessarily have to be peer reviewed, correct?
It does not necessarily need to be.
It is one of the factors that can be considered.
That is true. That is one of, those are some, and there are others that can and should be looked to make that reliability assessment. An expert's opinion testimony need not meet every single Daubert factor, but the ability to meet none of them or the ability to meet only a few of them speaks highly in the Daubert jurisprudence to whether that expert's methodology is reliable or not.
Do you think the use of the factors would make our results in terms of gatekeeping on experts consistent not only with other states and other jurisdictions following Daubert, but also more consistent internally within New Jersey?
Yes, I do, Justice Lavecchia. I think it absolutely would.
And how about, what would it do in terms of facilitating uniform appellate review?
Well, I think with clear guidance from this court with respect to the standards that our trial courts are required to use, I think that will help with the abuse of discretion review that our appellate division will take when they look to that record to see whether those factors and other aspects of the reliability calculation have been properly applied by the trial court in that setting. Another example that we gave...
Would you admit that even under Daubert there is sufficient flexibility that there are going to be, and there are differences from one courtroom to another?
Absolutely. There are differences under the Daubert standard, of course.
In fact, that was one of the criticisms of Chief Justice Rehnquist when Daubert was actually adopted by Justice Blackmun, was the increased flexibility.
Well,
I'm not suggesting that Daubert is more flexible than our standard. It's just that there already is built in a certain degree of flexibility. correct?
Yes, of course there is.
Well,
There's-
that's in terms of flexibility to move past general acceptance, which was a rather rigid standard, wouldn't you say?
Yes, yeah, I agree, Justice Lavecchia. Another example that we gave in the materials, I think it speaks to this issue, was in the Seroquel and Risperdal litigation, where we had parallel litigation going on in Delaware, which has adopted the Daubert standard, and here in MCL in New Jersey. And in that litigation, we had the plaintiff's chief causation expert, an endocrinologist, who was barred from testifying in Delaware under a Daubert standard. But when that same expert came across that same river, albeit from Delaware into New Jersey this time, that expert was permitted to testify in an MCL litigation here in New Jersey. The expert in that case was very well credentialed and spoke to a methodology that is a methodology that is used by scientists and other physicians. The issue was whether that methodology was reliably applied, and I submit that that is often where, in our trial courts, the evaluation of the reliability of an expert's opinion often ends. There's a great deal of emphasis placed on qualifications. There is, of course, an analysis of whether that expert uses a methodology or at least identifies a methodology that he or she is using, but there's very little analysis oftentimes in terms of whether that methodology is actually reliably applied.
Well, the trial court in this case was able to use the Kemp-Landrigan standard to bar the testimony, had no problem with it.
That's true. And as I said, I believe that our Kemp-Landrigan Rubanic jurisprudence does have aspects of it that sound a lot like Daubert, but our point is that in practical reality, that's not how it's being applied in our courts. And in the Risperdal-Seroquel example that I was giving, the MCL judge here in New Jersey, who's a very well-respected jurist and who now sits in the appellate division, recognized that the outcome could have been different if she were applying the Daubert standard. And we submit that the result here, in this case, is another reflection of an application or an understanding of our expert admissibility standards that is weaker than Daubert. The appellate division permitted the testimony of the plaintiff's experts here because, in its words, it's the jury's core function to weigh the credibility of expert witnesses, and the trial court should not use a Kemp hearing as a vehicle to dismiss a case the court perceives as weak. So under the appellate division's reasoning here, it's the jury's responsibility to identify and discredit unsound expert testimony, a position that we believe is...
But they're not going to do that on their own. Certainly they're going to do that based on arguments of counsel to them, based on the testimony before the court. And so the argument is in whether we should have a gatekeeper in the form of a judge. But what's the breadth of the scope of that gatekeeper's responsibilities? And I think here we've always had it instruct the jury, have counsel argue, and leave it in the hands of the jury.
Well, Justice Timpone, our jurisprudence does recognize a real gatekeeping responsibility for our trial judges. So it's not always left to the hands of the jury, and we don't believe it should be. For the reasons that Mr. Schmidt said, I don't believe it's fair to them in the context of a trial to be able to do that type of assessment of an expert's reliability in terms of their methodology and whether it's reliably applied all the way from start to finish. I think the need for clear definition from this court in terms of our expert admissibility standards couldn't be more vital. We have now 20,000 pharmaceutical product liability cases pending here in the state of New Jersey. In those litigations, we have 93% of the plaintiffs coming from outside of New Jersey. We think that that number is likely to grow in light of the U.S. Supreme Court's recent decision on personal jurisdiction in the Bristol-Myers Squibb case. We think that influx of plaintiffs to New Jersey is even more likely if the organized plaintiffs' bar continues to believe that New Jersey is a more hospitable forum for unproven, often unsound expert testimony. We submitted in the record a letter from a very prominent, very successful, large plaintiff's personal injury firm that has filed thousands, if not tens of thousands of cases here in New Jersey. This was a letter written in the context of the Vioxx litigation, and it was addressed to plaintiffs' lawyers around the country, and it urged them to file their Vioxx cases here in New Jersey. Why? Because of our weaker expert admissibility standards, and because Merck, as a resident of New Jersey, would be unable to remove those cases to federal court and get the benefit of the Daubert standard. So it's not just us, it's not just me, it's not just my clients, it's not just other members of the defense bar who are saying that in practice our expert admissibility standards are weaker. It's the organized plaintiffs bar saying that as well.
Mr. Fanning,
Yes.
if we were to agree with you in terms of moving our test in the direction you're suggesting, what would that do for cases that the court worried about in Rubanic when we were dealing with new causation frontiers or new areas in products liability and harm to individuals' health, where the line between hypothesis testing and hypothesis generating is blurry, and we're not sure when we have actually tipped over to the point where there's enough causative proof to allow somebody to proceed with a case that they feel they should be able to because they've been harmed, say here, by a drug that some company has produced.
Yeah.
Do we have to wait for 9 studies that prove for certain that the drug was the cause of the disease and to the exclusion of other causes?
Well, I start from the perspective, Your Honor, that generally speaking, and this is recognized in jurisprudence, I think in the Ninth Circuit, for instance, that science leads the law and the law doesn't necessarily lead science. But at the same time, I do think that the Daubert-based...
And they did say that eloquently.
Yes. and I do think that the Daubert factor-based approach allows our trial courts enough flexibility to take into account those types of situations like we saw in Rubanic and still make a reliability assessment with respect to that expert's methodology. When this court first looked at, or I should say when the Rules Committee first looked at the issue of whether to adopt Daubert, it was in the 2000 to 2002 term. And at that time, the Rules Committee declined to recommend a change to Daubert because at that time Daubert was relatively new. And certainly the Federal Rule of Evidence 702's adoption of Daubert was relatively new. It's not new anymore. Daubert was decided 25 years ago, and it has proven to be a reliable tool for testing reliability. When this court last heard from us, some of our clients in the context of this question again in May of 2015, in light of the Rules Committee's most recent report, there was some concern expressed by members of the court that perhaps the court should await the right case. In an adversarial context, with a full record, with stakeholders, including amici, having an opportunity to submit their points of view with respect to this important issue. And we view this as that case. We view this as this court's opportunity to join the mainstream, to join 39 other states and the District of Columbia, and of course the federal judiciary, and in adopting Daubert. We believe that doing so will ensure reliability of expert testimony offered in trials on a daily basis here in New Jersey, and as a result will also improve the administration of justice here in our state. Subject to any other questions that the court may have, I would like to thank the court for giving our clients the opportunity to submit their point of view on this very important issue.
Thank you, Mr. Fanning.
Thank you.
Mr. Greenberg.
Thank you, Chief Justice Rabner, and may it please the court, Bruce Greenberg for plaintiffs' respondents. The court has before it 2 different arguments on behalf of the defendants. The first argument is that the court should import into New Jersey law all or part of the federal Daubert standard, to the extent there is a single Daubert standard, as I'll address. The defendants themselves asserted that in their petition, but in their supplemental brief they seem to have backed off that position and have conceded that Daubert actually represents a similar standard to that of Rubanic. And the court heard something like that today as well from the defendants. The second position of the defendants is that under the court's existing jurisprudence, beginning with Rubanic and through subsequent cases, the plaintiffs' experts didn't comply with those precedents. No matter which of those shifting positions is considered, though, the appellate division's careful and extensive decision should be affirmed. For over 25 years, New Jersey's lawyers and judges have applied the Rubanic line of cases with care and prudence to ensure that only real science reaches juries. As needed, this court has offered guidance in doing so in cases such as Kemp and Hissenage. There's no reason to discard Rubanic and to replace it with some version of Daubert. To begin with, there is no single Daubert standard. The thousands of post-Daubert cases have encrusted that decision with contradictory principles. Often those cases have ignored the actual language of Daubert, which, like Rubanic, emphasized the liberal thrust of the rules and their, quote, general approach of relaxing the traditional barriers to opinion testimony. There are different Dauberts in the various federal circuits and in those states that have said they're adopting Daubert. Even those who try to catalog which jurisdiction applies which standard find themselves disagreeing about which jurisdiction does what. So confusing is the effort to identify what is Daubert. The court has only to compare its own committee's compilation in 2015 of the various jurisdictions with other summaries like that, such as those that NJCJI has cited here. The notion of a single Daubert standard that could be adopted here is an illusion. Since Rubanic and its progeny have worked well, this court has repeatedly declined to replace it with Daubert, as the court is well aware. The most recent occasion was in 2015, after the court's Committee on the Rules of Evidence found no confusion or inconsistent application of Rubanic in the lower courts. So much for the position of one of the defense amici that the court's current jurisprudence creates a confused and uncertain state of affairs. The court should reach the same conclusion here and should say once and for all that Rubanic and its progeny are the law of New Jersey and not some other standard. If repeal and replacement in Rubanic is off the table, what remains is defendant's assertion that the appellate division here failed to follow Rubanic. That contention is mistaken. Judge Reisner's careful and detailed opinion faithfully followed the court's precedents. Defendants simply don't like the result that led to. Defendants don't like that the appellate division labeled Rubanic a, quote, relaxed standard. But the term relaxed comes from this court's opinion in Kemp, just as Daubert talked of relaxing the barriers to expert testimony. And even the defendant's own supplemental brief concedes that Rubanic adopted a, quote, less restrictive standard. The appellate division said nothing new and did nothing wrong. Defendants don't like that their own primary source, the Federal Resource Manual on Scientific Evidence, says that epidemiology alone cannot and does not prove or disprove causation. In recognizing that, the appellate division said nothing new and did nothing wrong. Defendants don't like that Drs. Kornbluth and Madigan independently evaluated the epidemiology for potential flaws and offered their own interpretation of some of those studies. But in Landrigan, the court recognized that the validity of an interpretation of a study is one of the keys to the study's usefulness. And in Rubanic, the court, of course, said that the implications of a study are open to debate, but precisely for that reason, plaintiff's expert is entitled to describe the study and explain his interpretation to the jury. In permitting plaintiff's experts to do just that, the appellate division said nothing new and did nothing wrong. Defendants don't like that the appellate division distinguished between legal decision-making and scientific decision-making. But in Rubanic, this court recognized the differences between the judicial and the scientific technological processes and labeled them profound and pervasive. Even Daubert distinguished between, quote, the quest for truth in the courtroom and the quest for truth in the laboratory. So again, the appellate division said nothing new and did nothing wrong. Finally, as Mr. Buchanan will address in more detail, defendants don't like the way that Drs. Kornbluth and Madigan applied certain scientific concepts. But defendants' own experts recognized those concepts. They just applied them differently and reached a different result. That confirms that plaintiffs' experts employed recognized methodology based on data and information of the type that other experts in the field rely on, which is the test of Rubanic and its progeny. In Rubanic, this court said that courts should be loath to determine whether the particular expert has properly relied upon data which experts in the field generally rely on. In ruling that the opinions of Drs. Kornbluth and Madigan were sufficiently supported in such data, the Appellate Division said nothing new and did nothing wrong. In Hissenage, this court stated that our Evidence Rule 702 has a tilt in favor of admissibility, precisely because, as Rubanek also said, the decision to credit an expert's theory is left to the trier of fact. The decision below was correct and should be affirmed, and this court should emphatically reaffirm that Rubanek and that line of cases, and not some other standard, is the law of New Jersey.
Mr. Greenberg, come back to the standard, if you would. What do you make of the fact that such a high percentage of MCL litigation in New Jersey involves out-of-state plaintiffs? Does it have anything to do with the standard?
I don't think it does, Chief Justice Ravner. There are a number of factors that inform any party's decision as to where to file their lawsuit. There are certainly pros and cons of filing here in New Jersey. There were in the past, there continue to be going forward. Whether the standard for expert testimony, which in fact is largely identical to Daubert, as we've shown, is one of those factors, varies from lawyer to lawyer and from case to case. There are certainly reasons why people would file here. We have an excellent judiciary. The defendants are clearly subject to personal jurisdiction here, which they may or may not be subject to in home states of plaintiffs, especially after the Bristol-Myers decision last year. There's a large calculus that goes into where cases are filed, and there's no one factor, including this one, that would necessarily dictate that.
Can you address the way that amicus, I'll refer to them as the academics, have framed the differences between the two tests? What's your position on that?
I think that the differences between the tests are far outnumbered by the similarities. As I've indicated, both Daubert and Rubanek, or the Rubanek line of cases, Kemp in particular, use the word relaxed in terms of describing the move away from the general acceptance test to either the Rubanek test on the one hand or the Daubert test on the other hand. Both lines of cases have made clear that the test is now a flexible one, and that as Hissenage from this court said, there's a tilt toward admissibility. Daubert said the equivalent, that the liberal thrust of Rule 702 of the federal rules is oriented toward making it easier to bring opinion testimony before juries than before. Both the Rubanek line of cases and Daubert focus on the data and the methodology and not the conclusions, contrary to the approach before. Both of those cases or lines of cases recognize that there's a difference between legal decision-making and scientific decision-making. It may be that science leads law to some extent, but law needs to generate decisions in particular cases within a reasonable period of time, whereas scientific inquiry is ongoing and is a longer-term process. Both Daubert and Rubanek recognize that.
Do you think the outcome of this case would be any different if Daubert were applied instead of Rubanek?
It would not, Justice Alvin. The Appellate Division was correct under either standard, and the court should affirm that ruling regardless of what it does about adopting Daubert or not. The difficulty
with
with
the fact that both adversaries answered that question the same way reflect your fine advocacy or something about the test?
I think it may reflect the fine advocacy of other counsel. But I think what it reflects is that the cases themselves, almost in the same words, provide all the advocates with the same raw material, and we reach the same conclusion. When both lines of cases refer to the new standard as a relaxed one, for example, as well as all the other ones that I've indicated, all the other similarities, the only conclusion that one can reach is that the tests themselves, as the defendants have now concluded in their supplemental brief, are very similar.
So why would it be a disaster if this court decided to adopt Daubert?
When a decision like that would be made, there are 23,000 cases or so, according to Westlaw, that have cited Daubert. Those cases have gone in every conceivable direction and some inconceivable directions, and a number of them have actually gone in the opposite direction of what the Daubert opinion itself contemplated and stated expressly, which is to relax the standards and permit more liberally expert opinion to come in. That's not to say that junk science or the like is admissible under either Daubert or Rubanek.
No matter what standard you use, courts are going to disagree. This case is a perfect example. That using the Kemp standard, the trial court came to one decision. Using that same standard, the appellate division came to another one.
That's exactly right, Justice Alvin, and the nature of the fact that judicial discretion is to some extent involved in these decisions necessarily means that there will be some two judges or groups of judges who will come out a different way on the same body of evidence.
But that's apparently it's happening now, so why would Daubert make it any difference? Judges will always different, regardless of what standard we apply. You're suggesting that it'll be worse under Daubert, I think, but I don't see how. Could you explain that to me?
Well, Justice Fernandez-Vina, the way that would happen is this. This court's precedents are relatively fewer in number. They are relatively easy to understand. They have been applied faithfully by judges in lower courts with little difficulty. The court has concluded repeatedly, despite arguments by others, that the lower courts are in disarray, there's confusion, and the like. Most recently in 2015, the court concluded that that's not so. Importing a body of so-called Daubert law, when there are in fact many Dauberts, would confuse the situation exponentially compared to the ability of practicing lawyers and trial-level judges to apply the...
You know what's interesting? Both the trial court and the appellate division in this case both cite Daubert. Even as they're applying Kemp and Landrigan, they're also citing Daubert.
Well, and of course courts are permitted to cite not only Daubert but other cases that are decided under the Daubert regime. The appellate division did that as well. So have the parties. So the parties are not disabled from citing cases as analogous or persuasive that were decided under the Daubert regime. Where the problem comes in is if this court announces that Daubert, whatever that may be, is now the law of New Jersey, that's where the difficulty comes in, because there are so many conflicting pulls, so many cases going in so many different directions, that you would be importing into New Jersey law a concept that no one can actually even really identify, because the federal courts have come so far from what Daubert originally was.
Can you address the effect of the different standards on newer products that have not been tested in the scientific literature, the concerns in Rubanek?
Rubanek was developed before Daubert and did an excellent job leading the way in terms of precisely those kinds of products. The policy of the court then, as reaffirmed in subsequent cases, was to ensure that new products where causation is not intuitively obvious, if I can use that overstated phrase, compared to the way causation is in a classic automobile accident hit or the like, would be treated in a particular way. Rubanek has worked well in that regard, and the court has reaffirmed it repeatedly for good reason and declined to adopt Daubert. The original Daubert opinion had many of the same elements, as I've indicated, that Rubanek had. The problem with the way Daubert has evolved in the federal courts and will likely evolve in those jurisdictions that have adopted some version of Daubert is that there is no way to ensure that the original principles of Daubert are going to be followed. Here, the trial courts are well aware of what the original principles of Rubanek are, because this court has reaffirmed them periodically as necessary in cases like most recently in Kemp. So that's, I believe, the way that Rubanek is more effective in maintaining the protections for those cases involving those kinds of products than whatever might be considered to be the Daubert standard. It's also worth...
Doesn't there seem to be a problem, Mr. Greenberg, in the fact that we have a trial court doing a rigorous analysis of the reliability of the methodology used by your experts, and the appellate division looking at the exact same evidence and reaching a different conclusion as to the reliability of methodology? It seems to me we should not be having two courts in New Jersey reaching such diametrically opposed results in the same matter. And I'm wondering if that can be addressed, one, by a more clear gatekeeper function in the trial court that's proposed with a review subject only to abuse of discretion, and two, use of Daubert factors to really test how the methodology of experts like Dr. Madigan and Kornbluth actually applied their methodology to the facts of these studies and the facts of this case. That seems to be something different that happened in this matter than what we saw in Kemp or in Robanek.
Clearly, we saw something very different in the law division, Justice Lavecchia, as you've observed, than what occurred in the appellate division. And the reason, in our view, is this. The law division allowed itself to succumb to a temptation that I'm sure trial judges often face, especially in the summary judgment context, but also in the expert context. The temptation is that having identified an issue of dispute between the parties, the temptation is to go ahead and decide that dispute. But this court has made clear that those issues in both of those contexts are not to be decided by the trial level judge, but are to be left to the jury once an issue such as that.
I disagree, Mr. Greenberg. The trial court was doing a reliability assessment and looked at very specific problems he saw in the methodology being used by your experts. And just to reel off a couple of them, they used a methodology where they disregarded 8 of 9 epidemiological studies and relied on case reports and animal studies that the research manual lists as a lower hierarchical level in terms of reliability. They relied on Siverman, but they disagreed with the author's ultimate conclusions and used unadjusted results to reach the result that they wanted to reach. The prodrome, they say, is less than 2 years, should be less than 2 years, and they use smaller studies. But they don't agree to any meta-analysis to try to look at the larger studies that talked about it. And by the way, it's difficult to think that all of these reports that were published in the Journal of Gastroenterology ignored the prodrome issue when they agreed to publish those articles, and the authors ignored that. And they said the studies were underpowered, and that goes to the meta-analysis issue. They didn't do anything to correct it. So the trial court was onto something when he was pointing out these difficulties and asking himself, I think internally, would other researchers have done the same thing and result in a reliable hypothesis as your experts put forward? The appellate division said, yeah, it's debatable. We should have let that go to the jury. But the trial court viewed that as a gatekeeper function. And if we mean that the trial court should have a gatekeeper function, I find it difficult to fault the trial court for pointing out these problems. What do you have to say?
We're not faulting the trial court for expressing its concerns about the conclusions or the methodology of experts. Those issues were argued well by the defendants, and the trial court certainly could express that those arguments were made and considered. Where the trial court went wrong was to take the further step of lining up on one side or the other on those issues. What the trial court did, for example, was...
What you call lining up is essentially trial court made findings of fact and ruled in favor of the defendants. That's not lining up. The court assessed the facts, as Justice Rebecca pointed out, and then the court ruled based on its gatekeeper function. It's not that the court lined up for plaintiff or defendant, at least not from what I could see of the trial court ruling.
But what the trial court did was to do exactly what the court said not to do in Rubanek, which was to take particular studies, such as the Severaman study in particular, and to express the trial court's view that that study falls far short of reliable evidence.
But that's not what the trial court did. The trial court simply said, under our standard, you have to reach a threshold of reliability, and that threshold was not met. I mean, is there no threshold that has to be met? Is there no function for the trial court in making that determination? You have a well-credentialed expert who comes in and says, it's daytime when it's nighttime, but that goes to the jury. Is there a threshold? And if so, are they the gatekeeper? Isn't that exactly what happened here? You didn't meet your threshold.
There is a threshold, Justice Solomon. In Landrigan, for example, where the court talked about the need to ensure that the so-called self-validating expert who presents personal beliefs in the guise of scientific garb not be allowed to get to the jury. That's not what happened here. These were not self-validating experts. These were experts who relied on the very data and the very studies that the defense experts also cited at this time or at prior times, but simply came to a different interpretation of how to apply that evidence. There's no question that everyone agreed about the universe, for example, of epidemiological studies.
Mr. Greenberg, not that you need a life raft, but given the way you and Mr. Buchanan divided the argument, would this be a good point to hand the baton?
I think it would. Thank you, Your Honor.
Can I just ask one question? I have one question for you. Early remark. Were you, when you spoke about personal jurisdiction, were you suggesting that any of these plaintiffs, had they filed in their home states, might not have had a forum in which to bring their claims? Are you suggesting that?
Under the Bristol-Myers case that was decided only last year, the ability to get personal jurisdiction over corporations who do business nationwide was contracted to some extent, so that it might not necessarily have been the case that a plaintiff who lives in a distant state and took medication in a distant state in which the defendant is not headquartered or doesn't have its principal place of business might not be subject to personal jurisdiction there. Looking backward before Bristol-Myers, I don't think that everyone believed that that was the potential result, but after Bristol-Myers, which by the way, the very same defendants who are claiming that it was wrong for people to come to New Jersey, those same parties were the ones who advocated for that result in Bristol-Myers.
Thank you.
Thank you.
Mr. Buchanan, you're welcome to start by responding to the last few questions if you like, or however you would wish to proceed.
Well, Your Honor, I think I'll probably get to them pretty quickly. I'll do my best to address the open questions directly and quickly. The experts here, Dr. Kornbluth and Dr. Madigan, there is not an issue with respect to their credentials. Clearly, extremely well-credentialed scientists, reputations beyond dispute. Certainly at the hearing, there was no issues raised with respect to them. Moving into the second prong, though, of the 702 analysis, the issue becomes data and information of a type relied upon by experts in the field to answer the question for which they're answering. There's no dispute, I think, that they certainly analyze the same body of information. The question is what conclusions were drawn from that analysis? There's been a question drawn as to the reliability of the way in which they analyze that body of information. I'd like to start, Justice Lavecchia, with the epidemiology, because that was the focus of the trial court's decision. Recalling at the outset, though, that the only thing epidemiology can show is an association. In the context of this litigation, there has been an association reported since 1984 in the label with this side effect. Even to this day, notwithstanding the epidemiology, it remains reported that there's an association. So the question really becomes, is it cause or is it coincidence? That is the analysis of the expert, of Dr. Kornbluth. Is it cause or is it coincidence? And so what an expert like Dr. Kornbluth brings to bear, and he certainly analyzed the epidemiology as a primary focus of his examination. The trial record is helpful, or the record in the hearing is helpful, in seeing the methodology Dr. Kornbluth employed. He was an equal opportunity critic, as was Dr. Madigan. Both of them examined and critically appraised all of the studies. That is what our precedent requires, whether in this state or outside of the state, to critically appraise the studies. If there's a methodology challenge, it would be just taking point estimates and confidence intervals or statistical significance and saying that decides the issue, without examining how the studies themselves were designed or conducted. Dr. Madigan and Dr. Kornbluth did both. They analyzed how are these studies done? How are these so-called population studies done? And I'd like to address, I don't remember which justice asked it, in the largest studies or the biggest studies. Some context is relevant there. These are, quote, population studies. They're done in databases. But the number of Crohn's cases exposed to Accutane in these studies is very small, extremely small. The Edmonton study had 5 Crohn's cases in it, so-called population study. That's the Canadian study. Crockett study had 5. The Bernstein study had 14. Racine had 11. I think Al Hussein was the biggest one. It had 60 cases. 2,100 cases were dismissed by the trial court order here. A very large population of people, dwarfing the size of these studies and their size. So we have studies that by definition, frankly, there's no dispute in the record. Dr. Goodman said so, our experts said so, the reference manual and scientific evidence says so. These are flawed studies. They're epidemiology studies. When I say epidemiology, there are 2 buckets of epidemiology. There's observational data that's done in these databases like the ones here, and there's randomized controlled trials, which are experiments. These were not randomized controlled trials. These were not experiments. These were researchers searching into databases to see what could be seen. And when they're not experiments, that means there's a risk of confounding and bias. We don't have splitting the group on one side with placebo and the other side with the active drug to see, is there a difference in effect? What we have are observations of people who developed Crohn's disease and looking back to see maybe just 1 year were they exposed to Accutane within the prior year. What do we know about the differences in the groups of people who took Accutane and not? Were they smokers? Did they have a family history? We had some agreement at trial, at the hearing. One is that those are the 2 most important risk factors.
Is there a science basis that's known for causing Crohn's disease?
Generally? Yes. There are three components of it. I'd say the pathophysiology is known. There's got to be a genetic component. There has to be a trigger. And there's got to be an inflammatory component. Those 3 things are generally understood to be the pathophysiologic mechanism for Crohn's disease. Some triggers are known and well described. The inflammatory process is also known and well described. Indeed, Roche makes a drug that now blocks that inflammatory process, which is triggered by retinoic acid. Retinoic acid, the primary metabolite of Accutane, stimulates the inflammatory process in Crohn's disease and in ulcerative colitis. That was the mechanism described by Dr. Kornbluth. In the record, it's got scientific names. It's alpha-4 beta-7 targeting, that one of his primary mechanisms.
Did he ever place that in a peer-reviewed periodical?
No, he hasn't.
Why not?
No,
I mean, that would seem to be some tremendous scientific medical breakthrough. Why would you introduce that for the first time in a lawsuit? Why wouldn't you have that peer-reviewed?
That fact about retinoic acid targeting and imprinting inflammatory cells is well known. It's described in the literature. There were literature references to the hearing, Your Honor. Accutane's metabolite of retinoic acid is also well described. I know none of the experts have published. It's not uncommon in my experience that experts don't publish on their specific findings because they're viewed with. I'm sorry.
That would seem to be like the silver bullet. I mean, if you could actually show that there was an unrefuted biological mechanism that is actually causing Crohn's disease, you wouldn't need all these epidemiological studies. You would have that, but this proposition or theory has not even been submitted to a scientific journal.
It has.
Peer-reviewed, or it has?
It has. I mean, not by Dr. Kornbluth. It's in the scientific literature. The Shale publication is referenced in the testimony below. It's discussed within that article the inflammatory role that alpha-4 beta-7 or retinoic acid has in pushing inflammatory cells into the site in Crohn's disease patients. That article further concludes that Accutane may be a potential precipitant of Crohn's disease in UC. There are a number of articles that highlight the biological plausibilities. They're identified in Dr. Kornbluth's hearing.
Were those submitted to the trial court?
They were. Dr. Kornbluth identified its role on the second step, Your Honor, with regard to stimulating inflammation. He further identified its role.
I just want to be clear about this. Are you telling us that Kornbluth's hypothesis with respect to the retinoic acid is accepted within the scientific community?
There's clearly a debate. We have a debate with the defense as to Accutane's role as it relates to inflammation. The defendants have highlighted some studies that they say actually it suppresses inflammation. We have several studies that show it fosters inflammation. So yes, we have a fuss, if you will, on acceptance on Accutane's role or retinoic acid's role in inflammation. There's another mechanism that Dr. Kornbluth described in depth. It relates to the exfoliation and degeneration that Accutane can have on the GI tract. That's been seen in animal studies, toxicology studies, which the reference manual identifies as an appropriate line of evidence, even in the presence of epidemiology or inconclusive epidemiology or no epidemiology. Toxicology is controlled and can provide, and he extrapolated from the studies appropriately and explained why it was appropriate to rely on those. The dog was considered an appropriate model to evaluate the GI tract in human beings. Those are Roche's words. It's a Roche internal study. The study, certainly the one with regard to Accutane's primary metabolite, has never seen the light of day. It has never been published. It's not referenced in the peer-reviewed literature. It's not cited in any of the authors who are looking at this assessment to try and do a more global assessment of causality.
Would you respond to Mr. Schmidt's earlier argument that the doctor had some criticisms of the studies that he did not apply across the board, and that's not a reliable methodology?
Yes, Your Honor. The studies that would be, the criticisms that would be raised for certain studies are appropriate in the context of a type of body of evidence. When you're looking at epidemiology, the reference manual says and the experts say, you need to look at biases. You need to look at sources of potential confounding that aren't accounted for. So that line of data requires you to analyze, is that finding one that's reliable? Can we trust that finding? Certain confounders were not controlled for. Is the population...
Counsel, I think the argument was not what you're suggesting. The argument was that the methodology applied to disregard the studies. Some studies would have also applied to the ones he relied upon, and he did not apply that methodology or that analysis to the studies that he relied upon. I think that was the argument.
We greatly disagree with that characterization. I mean, Dr. Kornbluth identified the specific concerns with the epidemiology. He also identified the specific limitations of the other lines of evidence that he considered. With regard to dose, I think the argument was he didn't consider dose as it related to animals, or he didn't consider dose as it related to case reports. He precisely did. We've cited it in the record. He considered the role that dose and dose escalation played in bringing on events. We have a sharp dispute with the defense on this factually, and I expect to see those arguments in a closing argument at a trial about whether the expert had appropriately, or what inferences could reasonably be drawn from his consideration. But there is no question that the expert, as it related to the epidemiology, considered all the strengths and limitations. It's discussed at length in the detailed directs and crosses. But there's also alignment with the defendants and the defendants' experts outside of court with the methodology to use. First of all, with regard to epidemiology, both sides agree, and the reference manual so states, that in looking at epidemiology, the failure to see a statistically significant result is not the end of the story. The next step is, okay, what's the range of plausible or true values from the study? Examine the full confidence interval that's reported for the study. That's what plaintiffs' experts did. They identify broad ranges of increased risk for Crohn's disease from several of the studies. One of the studies, the Severman study Your Honor asked a question about, reported a statistically significant increased risk. There was a fuss in the hearing about whether it was appropriate to rely on the statistically significant result or the non-significant result, which is after they pulled out patients who had been exposed to antibiotics. Both Dr. Madigan and Dr. Kornbluth explained why it was appropriate to do that. I'd submit that is certainly an issue for the trier of fact. Methodologically, they explained very clearly why they did so. This was not a case of just say-so of an expert.
But is it normal for an expert who's trying to show reliability in terms of their methodological approach to take a study like that, disregard the ultimate conclusion, adjust the results, and then reach their own conclusion? Is that typical?
It is, and frankly, it happens all the time, where the discussion of a study...
But that really is the basis for their opinion, is it not? That's the key study on which they rely.
I'd submit, Your Honor, it's not. I mean...
Well, there are two very small ones, right?
Yes, and the gates to the causation analysis here are that there's an association. That's really... There's been a lot of focus on the epidemiology, and the epidemiology studies provide point estimates and confidence intervals, and they can help you characterize the risk. But Dr. Kornbluth certainly highlights that, yes, Severman was statistically significant. Yes, Racine was statistically significant, negative. There were others that had positive associations and others that had negative associations that were not significant. But that really is not the crux of the opinion. It is a piece of evidence that supports the existence of an association. But there's a lot of other evidence that supports the existence of an association. The evidence, Justice Allen, I think you were referring to earlier, that goes even further back in time. We have, obviously, challenge, de-challenge, positive, re-challenge cases.
Case studies.
What's that?
Case studies. That's
There
what
are
you're
case
pointing
studies,
to?
yes. There's been causality determinations, and we have, in terms of the existence of an association, the company's own words about the existence of an association, their own determination that it's causally associated. The question...
Well, that was
But that-
earlier. I mean, look.
It hasn't
they
changed.
What they were doing was reporting adverse events to the FDA and making disclosures. People were saying that, you know, I took Accutane and, you know, a year later I came down with Crohn's disease. I mean, so they were doing what they were supposed to be doing, correct? In terms of reporting that.
Yes.
They didn't necessarily have to know whether or not there was causation, but there was association. Taking the medication and in Crohn's disease.
Well, they did two things, Your Honor. They certainly, as they received reports, they reported them to the FDA. But they also internally assessed them for causality. They internally rendered conclusions on them which they kept to themselves. They determined whether or not, from their determination, Accutane was causally related or not. And they made findings of possible or probable causality. And ultimately, I think in 2000 or so, expressed that it had been causally associated with IBD. They don't delineate between Crohn's disease and UC, but they draw no distinction between Crohn's disease and UC.
But there is a difference between the two.
There clearly is a difference between, the company drew no difference in its internal assessment at that point in time. Whether you get to do the further causal analysis, whether you look at these other lines of evidence, when there's inconclusive epidemiology, the reference manual says there's no hard and fast rules. Dr. Goodman's writings, which were presented below, said there are no hard and fast rules. His statement was that you can do a Bradford Hill analysis when there's just a signal. You don't need statistical significance. You don't need all the studies to line up. You don't need a meta-analysis. You can do the type of causal analysis that Dr. Kornbluth did when there's a signal. There was further evidence presented, Justice, during the hearing about the disproportionality analyses that were done in the literature in 2005, which showed a 19-fold difference in reports for Crohn's disease, and the one that Dr. Madigan did withdrawing lawyer reports. And I would like to address that comment because, Justice Alban, I think you highlighted the court's, I'd say, concerned language in the decision about the resourcefulness of plaintiffs' lawyers in, I'll say, distorting the database with the FDA. Plaintiffs' lawyers have not reported events to the FDA. We have not done that. Unequivocally, I will tell you that. The events have been reported by the company to the FDA. Plaintiff gets injured, brings suit, wherever they bring suit. The company, as part of its pharmacovigilance responsibility, reports those to the FDA. Within the FDA database, they get noticed as an event reported by a lawyer because we reported it to the company through our lawsuit. In no sense have we done anything to distort the adverse event database. But importantly, when Dr. Madigan looked at the events without lawyer reports, there still remained a strong and significant signal for Crohn's disease. With a strong and significant signal for Crohn's disease, the broader Bradford Hill analysis was appropriate under Dr. Goodman's framing, under the reference manual framing, and also Dr. Alva Hemker's framing. She testified, and the appellate division decision references this, that in, I think it was 2012, she had done an analysis of causation where the epidemiology did not support an increased risk. There were no studies that pointed to an increased risk of ulcerative colitis in that case. But she nonetheless did an analysis with animal studies, with biological plausibility, with reports in the literature and her knowledge of the biology, and reached a conclusion that, in that case, antibiotics were a cause of ulcerative colitis in that particular plaintiff's case. And she testified at trial with that opinion. The slide is in the record. It's been cited in our briefs. Dr. Alva Hemker, in the context of that trial, said that animal studies are hypothesis testing. Hypothesis testing.
I saw somewhere in the record that dogs cannot get IBD.
To the best of my knowledge, that remains true. So the animal studies or the toxicology studies that were done to show Accutane's acute effect on the GI tract. And what they showed was exfoliation or stripping of the lining of the dog's GI tracts, invasion of inflammatory cells, and the development of crypt abscesses, and I apologize for the science, Your Honor, but which is a hallmark of IBD. So yes, the dogs didn't develop frank IBD, they're sacrificed at the end of the trial, but in terms of the pathophysiology of what we know about Crohn's disease, they developed a lot of things that point to a mechanism through which Accutane can have that effect.
I promise not to tell my dog tonight.
I should note
So
that
your adversaries are basically saying there's a hierarchy of evidence. The epidemiological studies is the best. They're not to your advantage. So what you've done is tried to deconstruct every one of those studies and therefore rely on lines of evidence that are less reliable. That's their argument.
the hierarchy of evidence that's highlighted by the defense appears, as the appellate division noted, in the medical testimony portion of the for medical decision making with regard to how to prescribe or not prescribe. At the top are randomized controlled trials. With the reference manual notes in the epidemiology section, with regard to observational trials in particular, is when there's observational studies and animal studies or toxicology studies, there's no clear rules on how you reconcile the differences between the two. It's subjective as to how you bring the two to bear. The references from the reference manual were cited. Dr. Goodman stated that you should incorporate all of it: animal studies, observational studies, mechanistic information. Dr. Alda Hempker previously did that with her consideration of UC and antibiotics for the alternate cause in a case in 2012. So I'd submit, Your Honor, this hierarchy is frankly something that's been described, but in terms of scientists and what scientists do outside of court, including our experts and the defense experts, they consider all those lines of evidence, the strengths and limitations, analyze them critically, and make the ultimate conclusion. There are no hard and fast rules as it relates to causation.
Standard of review. Do you agree that the standard of review for the trial court's ruling is abuse of discretion, period?
The appellate division obviously noted that the trial court had misapplied its discretion. There's cases from this court that have been...
That's a different question. I'm trying to figure out what your position is on the standard of review. Is it a strict abuse of discretion standard?
Your Honor, I think this court's cases would say if the court has applied the wrong legal standard, or if it had the wrong legal test when it was evaluating the evidence before it, then this court would sit de novo. But as a practical matter, I don't think we get to a different place. There is language in the court's decision where the court states as the standard the rejected language from Urbanic. The court, at the beginning of its decision, the trial court, states that it's analyzing this for strong, robust, repeated studies. That's the test of a proper scientific methodology for purposes of an opinion. That is the rejected standard from Urbanic.
I'm still trying to figure out what the standard of review is. And I'm not certain that you've answered my question. Is it abuse of discretion?
We believe, Your Honor, it's abuse of discretion unless the court has applied the wrong legal standard.
Well, that would be an abuse of discretion,
of
wouldn't
course.
it?
Some of the court's authorities have highlighted that as a basis for there to be abuse of discretion.
Other questions, anyone? Thank you. Mr. Plescal.
Morning, Your Honors. First, thank you for the honor and privilege of allowing me here to argue this morning. Now, in these hallowed halls, every lawyer in this room has dedicated his or her professional life to the proposition that it's the collective wisdom of the jury when evaluating the credibility of witnesses and sifting through the facts that's superior to even the most able and well-intentioned jurist. And it's on that foundation that this court recently reminded us in the Cuevas case of the constitutional foundation of what we all do. When you stated, in our constitutional system of civil justice, the jury, not a judge, is charged with the responsibility of deciding the merits of a civil claim. And it's on that foundation that this court has established the rule of law that requires a trial judge to ensure that the expert testimony has the proper evidentiary foundation, while leaving to the jury the determination as to whether the expert's opinions should be accepted or rejected. It has been the wisdom of this court that it is beyond the prescribed role of the trial judge to independently evaluate whether one accepted methodology is superior to another accepted methodology, or whether the opinions of one expert in the court's view is stronger or better than the other. And to Justice Alvin, just to address an issue you raised before. So on this side, we talk about epidemiologic studies that are subject to criticism. Do they have the proper latency? Over here, you have all of the other type of evidence. Animal studies, case reports, biological plausibility. You know, they proved scrotal cancer occurs in chimney sweeps on the basis of one case report. And what happened here is what was not supposed to happen. What happened here was the trial court took one set of methodology and totally discounted the other methodology, when the proper thing to do, I respectfully submit, was to say, look at the body of the methodology and issue. Is there enough here to go to the jury? You know, it's a tribute to our court system.
What is your view of the gatekeeper role then? Based on the argument you're making, what exactly is the gatekeeper role position?
The gatekeeping role of the trial judge is to make sure that the court, that the expert is applying an accepted methodology in coming to his or her conclusions. And they can look at those, they can look at the studies and see if that is happening. But what happened here, I submit, is something that was not contemplated. And if you look at our trial courts, every year it's a tribute to our system how few cases come before you and before the appellate courts concerning the admission of expert testimony. Every year, thousands of cases are resolved under the premise of satisfying the integrated and coherent law that this court has guided us on in Rubanek, Landrigan, and Kemp. And the procedural safeguards that you have put in place with the Kemp 104 hearings, they should not be thrown out and discarded. They are working. They are not mini trials. That's what the defense would like. The purpose of a Kemp hearing is to determine whether the information relied upon should be admissible, not to assess credibility. And at the end of the day, there was a lot of credibility assessment going on here that we submit went beyond the role of what a court should do. A court, I mean, you look at the opinion and it calls the plaintiff's lawyers hired guns. That's a red flag that the trial court has gone beyond its prescribed role and gone into issues of credibility and not admissibility. This Supreme Court, this court's own committee, studied this issue very delicately and extensively and came to the conclusion that our courts are consistently applying the standard and doing it correctly. On the other hand, Daubert, with its best intentions, if you really look at what's out there, the interpretation of Daubert has created varying and inconsistent results. We submit that our law is clear, it is fair, and in its practical application, which is something we need to think about, is far less time-consuming than dealing with the Daubert standard. If you adopt Daubert, it is almost invariably will happen that the lawyers on both sides of this podium will pummel the trial court every time there's an expert challenge with decisions across the country with inconsistent interpretations to in their best advocacy, get where they want to be. That does not mean that a court could not look at a Daubert factor and say, well, for example, was this a peer-reviewed article? That is an accepted methodology. But that's not new to our system of justice. The courts has always looked to see if there was a peer-reviewed article or not, or whether an animal study has been accepted. We have cited a number of studies to you that clearly demonstrate the burden that has been created on state courts that have adopted Daubert and tried to wrestle with all the interpretations that have come before it. And the number of cases where the courthouse doors have been closed to people who are injured who would otherwise have had the ability to get to a jury. It is very telling, I submit to the court, that in its reply brief to our brief, and maybe flattering, that Roach actually admits that our law is fair and that there is no need to change the expert standard to resolve the merits of this appeal. And I quote from their brief, this court's decisions in Rubanek, Landrigan, and Kemp already provide a fair pathway for the introduction of novel scientific testimony. So, in terms of the rule of law, there's nothing broken that needs to be fixed. What we have is working. New Jersey law properly balances and respects the role of the jury and the role that you've imposed on the court in evaluating whether a methodology is the type relied upon by other experts in the field.
Are you saying Daubert is not as accurate as the test we use now, Rubinek and Fry?
What I'm saying is the tests we have now provide clear guidance, and they are fair.
Well, the reason I asked is earlier you said Daubert would keep people with legitimate claims out of court. I'm assuming from that this would be the converse.
I think because...
Are you saying that Daubert is more stricter than what we have and would keep more people out? Is that your opposition to it?
Yeah, I think in its original intent, that wasn't the case. But in its interpretation and how it's been interpreted in varying places, that is in fact what has happened. The way Daubert has been applied, and we gave you that little map in our brief to show you that it's not always the same, but the way Daubert has been applied, it has encouraged, depending on the interpretation the court cited, it has been applied to encourage courts to cross over from the line of evaluating whether the methodology is sound to actually resolving questions of fact and looking at credibility.
Can we forget about Daubert for a second? Can we improve upon our jurisprudence and give further guideposts that would channel the discretion of our judges? Maybe incorporate some of the factors that some of the cases have elaborated on with respect to Daubert?
Your Honor,
go ahead.
Justice Alvin, I believe they're already there. They're written into our decisions. Our courts are doing a great job of applying what's there. Look at our history. And
so, of those factors were further articulated, then your response is we would be doing nothing new.
You would be doing nothing new. I think it's already there. In this context, we submit that the court should determine here whether the trial court faithfully followed the rule of law that you've so clearly set forth, or whether they crossed over the line, whether the trial court crossed over the line and usurped the role of the jury. That, I think, is the core question when you listen to both sides. We believe that if you look at everything that happened, yes, the court was well-intentioned. Yes, the court worked really, really hard. But the court did blur the lines. The court evaluated credibility and not admissibility. It did look at admissibility as well, but when it starts saying this kind of study is better in this context than this kind of study, and then they try to get in, and the court tries to get in that bridge between the methodology and the conclusions, the court here went too far.
Isn't that exactly what Daubert in its present iteration with the additional words added to the federal rule requires in application? It's not just that an expert identify a sound methodology that's recognized for use generically, but how that sound methodology is being applied to the facts of the case. That has to be shown to be done and reliable such that other researchers would agree that they would do it too. Do you agree with that?
I think there are courts that have said that that line should be crossed. I don't believe that was the intent.
That's in the federal rule now.
I don't think the federal rule says that the court should be weighing the credibility of experts.
I'm not saying credibility. Applying the soundness of the so-called methodology that is being identified by the experts for use in this matter, and whether it is being applied reliably in this particular case. That is part of the totality of the analysis that, as I understand it, the federal rule requires.
And I don't really see that this court's precedent changes that very much.
Okay, so you agree with me that that should be done.
I think I do agree that, and that's why I say our law is not broken. But I do believe that in its interpretation in various jurisdictions, depending on the court and the context, that Daubert has created inconsistent results, and that the standard has not been integrated and coherent. We have an integrated, and we led the way. We were long before Daubert. We led the way. Our judges know how to apply this law.
So just to be clear,
Maybe not.
are you saying that there's no difference between our current jurisprudence and the federal rule of evidence on expert testimony in its 4 factors, A, B, C, and D?
I think the intent is the same. The problem is that when you say you're adopting the Daubert standard, you are injecting 50 state interpretations.
I'm only asking you whether or not the factors, as they are articulated in the federal rule, are any different than the principles that already exist in Kemp, Landrigan, and Rubanek.
The factors that are in the federal rule under Kemp, Landrigan, and Rubanek may be considered.
But you agree, or you said in answer to Justice Levecchia's question, that the trial court here, our trial courts, do a terrific job of applying our standard, which includes a finding that the methodology was applied to the facts in this case in a sufficiently reliable manner, correct?
Yes, sir.
And yet here, the trial court said, based upon all of the evidence, the standards, the testimony, not necessarily credibility, but based on the standards that I have before me, the application is not sufficiently reliable. You didn't cross that threshold. She applied that well-established law in a way that our trial courts do every day and came up with a different conclusion. What's the problem?
Because what happened here was you had a number of methodologies that were competing, so to speak, for getting to the end result. What the trial court here did was totally discount a set of methodologies, more than one I might add, that were reasonably relied upon by experts in the field, that their own experts agreed were reliable, totally discounted those.
And that was Mr. Buchanan's argument.
Right, and only accepted one methodology. Now, if it is true that a jury would would accept the criticism of that methodology, for example, because the latency wasn't long enough, then what actually happened here was the trial court rejected all the methodology that could be considered by a jury to come to a conclusion. And that's why when I started and I said the collective wisdom of the jury matters, because the jury would have listened to the criticisms of our experts or their experts on cross-examination. They would have listened to the criticisms of those experts, because now you have methodologies that everybody agrees were accepted. And what happened here is the trial court drew the line and said, your methodologies I don't accept, your methodologies we do.
In this setting.
Yes.
In this setting, as applied to these facts and what we know, the trial court said he did not find the application of that methodology to be reliable.
And I'll ask you to draw your argument to a close as you answer that question.
Isn't that correct?
The court did say that.
Yes.
I don't believe in practicality that's exactly what happened. What the court did is they only accepted one methodology and then looked really at credibility and made credibility findings concerning the plaintiff's experts, and that's the line that you've always drawn, and we should continue to draw. Our law is not broken. We don't need a fix. Our judges are doing a great job, and respectfully, this court has done a great job in giving guidance to our courts on how to proceed. Thank you very much.
Mr. Schmidt, rebuttal.
Justice, just a few words. I want to start by being absolutely clear on our position. In our petition for this court's review, we said, although the court need not adopt the federal Daubert standard to find that the appellate division erred, this case illustrates the benefits of doing so. Our principal argument, though, was that the appellate division's published ruling will have the effect of reading meaningful gatekeeping out of New Jersey law, and that's precisely the argument we advanced in our supplemental brief, precisely the argument I've tried to advance here. Under this court's precedents, reasoning matters. In the words of Kemp, the analysis and reasoning process applied to the facts of this case are the key. Under Landrigan, the court should examine each step in Dr. Sokolowski's reasoning. That's the reason that a Kemp hearing exists. It wouldn't be needed if it was this kind of pro forma, do they say Bradford Hill, that the plaintiffs urge. That's the reason trial courts are told to review the scientific record so they can understand, is this expert doing something with that record in their reasoning that no one outside of court does. That's the relaxed focus that this court adopted. Relaxing the focus from general acceptance to allow some non-generally accepted theories to go to a jury if they're based on a scientific methodology. The plaintiffs, in our view, want to take that one step further and say that focus on reasoning, that relaxation, should be taken out of the law anytime an expert says, I used what's recognized to be a reliable methodology, even if I contradict myself in the way I use it.
Let me just ask you two quick questions. There's been a representation that your client agrees that there is a causal association between Crohn's disease and Accutane, correct?
That representation was made. I don't think it's accurate. That is a reference to a single document where someone says, citing the internal version of the company's warnings, Accutane has been found to be causally associated with inflammatory bowel disease. It's not something that Dr. Kornbluth relied heavily on. If it meant what they said, that would be the sum and essence of his opinion.
That's not true. That's not correct. You don't admit that causal association.
No, we don't admit that causal association.
There are a series of methodologies that were used by Dr. Kornbluth and the plaintiff's experts. They say that you acknowledge that those methodologies are accepted. Which of those methodologies, whether animal studies or whatever, do you contend, and have you never agreed, are accepted?
What we agree is accepted is that the Bradford Hill methodology is a recognized methodology for concluding causation. What we don't agree is that he has applied the Bradford Hill methodology in anything close to how it's supposed to be applied. And I'll give two examples. The Bradford Hill methodology emphasizes looking at the strength of the association. Case law recognizes that typically involves looking at whether there are significant epidemiological findings. He ignored all of those findings.
Those are statistical analyses, correct?
Yes.
They're not biomedical, they're not anything like Justice Alvin asked about, if you've got the mechanism that causes Crohn's, doesn't that get the plaintiff all the way home? Epidemiology is stats.
It's testing.
Probability.
It's testing of the mechanism. It's testing of what we've
Of the
seen.
biological mechanism?
Yes, absolutely. If the biological mechanism is true, and Dr. Kornbluth acknowledged his mechanism was a theory, if it's true, we'd see it in the studies. If the mechanism explains how Accutane is causing Crohn's disease in humans, we'd see more Crohn's disease in the studies in Accutane patients. If the case reports that we've seen were caused by Accutane and not by other confounding factors, not by the risk factors,
But
we'd
that's
see that in
still
the
a
studies.
statistical analysis. It doesn't prove or disprove, well, it would prove the mechanism if it shows no incidence. No, but it's strictly a statistical analysis.
It's the best tools of science.
I'm not
to
saying
say,
that, not disagreeing, I'm just asking. Epidemiological studies are purely a statistical analysis. How many people that take this drug get this disease? Not why, not what the mechanism is, how many? Isn't that right?
It's a comparison. It is statistics. I think it minimizes it to say it's simply a statistical analysis. It's the best effort available to compare. Do we see this more in people who have used the medicine than in people who haven't used the medicine? The language that this court has recognized in its gatekeeping precedent about reasoning and about methodology means nothing if, in a case with developed science, an expert can simply say, I don't like this data based on one standard, and I disregard this standard for the other data I like. And I'll give one example of that came up in the plaintiff's argument. We heard a long argument for disregarding the epidemiological studies, for putting them to the side. But what about those dog studies? That's what their analysis, that's what Dr. Kornbluth's analysis depends on. The dog studies are equally subject. Just as one example, every one of his lines of evidence is subject to the same criticism. The dog studies certainly are. They have the same prodrome problem. They have a dose issue in terms of involving high dose. They don't involve IBD, let alone Crohn's disease. The argument that those studies can be compelling, highly significant, tell us what happens in humans. But human studies, looking at human beings who have IBD, who have Crohn's disease, can be dismissed on bases equally applicable to the dogs.
But this is going back, so they're attacking your studies, you're attacking their studies, and then they're saying, let the jury decide this. You both have methodologies. Your methodology may be better. Theirs may be subject to criticism. Why isn't this going before a jury?
And the two reasons are methodological reasons. One, we know that studies of disease in humans are superior to studies of an analogous condition in dogs. The hierarchy of evidence matters. Two, it's not simply we're offering our criticisms to them and they're offering our criticisms to ours. They're internally contradictory in what they're doing, and that's the second methodological issue. It's not simply a difference of
I know
opinion.
that you attack one of their studies, and then, like Justice Sullivan pointed out, one of your reports has what your adversaries would say is an admission of causality. Now, I know that you're saying, well, that was just like one cherry-picked line, but that's an argument they're making, and they're saying now you're being inconsistent. You have an internal report that says that, and now you're rejecting it.
If that was really an issue with our experts' methodology, they would have raised it. Methodology requires there to be consistency in the standards that they use. Our argument is not that they're wrong or they're right on the science. We think they're wrong, and that's what we would present to a jury if we went to a jury. But our methodological argument is you can't have a standard that lets you say all the best science is worthless. It doesn't reasonably inform my views because of these same issues that apply in spades to the evidence that the expert wants to embrace to make an argument. That's not science. That's advocacy. That's why gatekeeping exists. If a focus on reasoning means anything, it means that's not reliable. And I'll close with just one point. It's unlikely the court will ever have a record like this in front of the court again, where not only is there a hypothesis, but it's been tested again and again and again. And every testing of that hypothesis shows the same thing. The hypothesis is not supported. And every scientist who looks at that testing concludes, using the methods of science, the same thing. That hypothesis is not supported. And there's one expert who says, I can come to a different view by using a methodology no one in the scientific community uses, that literally inside court contradicts itself in terms of how he handles different types of evidence. That's why gatekeeping exists.
Thank you. Thank you to all counsel.
Thank you.